This video includes the important articles taken from The Hindu newspaper, August 2022. This article from the Hindu newspaper is a detailed analysis of section 295A of the Indian Penal Code, legality of this section under Indian laws, and how blasphemy and hate speech are treated in India. Blasphemy simply means any insult or disrespect by a person about the religious beliefs or the god or deity or any of the sacred things related to a religion. Hate speech means any abusive or threatening speech made by a person on the basis of religion, race, caste, creed, ethnicity, sex, etc., and it has a wider connotation than blasphemy, and it is not defined anywhere in the Indian laws. Even if both the terms are not defined, there are provisions in the Indian Penal Code 1860 relating to blasphemy and hate speech, and these are section 295A of IPC and section 153A of IPC. Section 295A of the Indian Penal Code says, there is any deliberate or malicious intention to outrage the religious feelings of any class by insulting its religion or religious beliefs, he shall be punishable with imprisonment for a term of 3 years or with fine or both. Similarly, under section 153A, promoting enmity between different groups on the grounds of religion, race, place of birth, residence, language, and offence committed in the place of worship, there shall be imprisonment for a term of 3 years or 5 years, respectively. The next topic is about the Medical Termination of Pregnancy Act. Recently, the Supreme Court raised a question with regard to the abortion law in India, which restricts unmarried women from terminating pregnancies up to 24 weeks old. In this context, let us discuss what are the laws concerning abortion in India. Firstly, under section 312 of Indian Penal Code, causing miscarriage is punishable. This section says, whoever voluntarily causes a woman with child to miscarry shall be punished with imprisonment for a term of 3 years or with fine or with both, and if a woman who causes herself to miscarry is punishable for a term of 7 years. As an exception to this, the Parliament has enacted the Medical Termination of Pregnancy Act in 1971 as per the report submitted by Shantilal Shah Committee, and recently in 2021 the Medical Termination of Pregnancy Amendment Act was passed, and the major changes are: the amended law needs the opinion of 2 doctors for pregnancies between 20 and 24 weeks. Earlier it was 1. Further, for pregnancies between 20 and 24 weeks, rules specified 7 categories of women who would be eligible for seeking termination. These 7 categories include survivors of sexual assault or rape or incest, minors but only with the consent of the guardian, women who change their marital status during the ongoing pregnancy, women with physical disabilities, mentally ill women including mental retardation, the fetal malformation that has a substantial risk, women with pregnancy in humanitarian settings or disasters or emergencies. Unmarried women are also covered under this act. Moving on to the next article, which is a review on an early judgment passed by the Supreme Court in 2017 that is connected with right to privacy. From the examination point of view, it is important to study what is Article 21, how the case Puttasamy vs. Union of India is connected with right to privacy. In 2017, a writ petition was filed in the Supreme Court by retired Justice K.S. Puttasamy challenging the constitutional validity of the Aadhaar Act 2016. And in this case, the Supreme Court held that the right to privacy is an inherent right under Article 21 and is declared a fundamental right by the Supreme Court. In the other case, the Supreme Court held certain provisions constitutional and certain provisions not, on the basis that it is violative of the right to privacy under Article 21 of the Indian Constitution. Now we shall have a closer look into what is Article 21 of the Indian Constitution, why this article is known to be the heart of the Indian Constitution. Article 21 of the Indian Constitution says, no person shall be deprived of his life or personal liberty except according to a procedure established by law. Hence, it is clear that Article 21 can only be claimed when a person is deprived of his life or personal liberty by the state and not by any of the private individuals. The meaning of right to life has been given wider interpretations in various Supreme Court judgments. It has a much wider meaning which includes right to live with human dignity, right to livelihood, health, pollution-free air, right to internet, etc. And thus its meaning includes all aspects of life which makes a man's life meaningful, complete and worth living. In Indian law, the concept and procedure of bail has been given in the Code of Criminal Procedure 1973. Here in this article, the Supreme Court has repeatedly mentioned about a legal principle that was evolved, that is, bail is the rule and jail is the exception. This legal principle was evolved in 1978 as a legal principle in the case State of Rajasthan versus Balchand. The term bail has not been defined anywhere in the Code of Criminal Procedure, but the terms bailable offence and non-bailable offence was defined under Section 2A of the Code of Criminal Procedure. Remember this, the bail can be granted only by the court. Now let us see what are the different types of bail. There are three types of bail: regular bail, interim bail and anticipatory bail. In a regular bail, the court orders the release of a person who is under arrest from police custody after paying the amount as bail money. And the accused can apply for this bail under section 437 and 439 of CRPC. An interim bail is a bail which is granted by the court to the accused for a short period of time for the purpose of preventing an unlawful detention. And this bail is granted before the hearing of a regular or normal bail and anticipatory bail. And the third category is anticipatory bail. When a person is feared of being arrested, he can apply for an anticipatory bail, and it is applicable to non-bailable offences. We are discussing this article in order to get a summary of the judgment in the case S. Subramanian Balaji versus Tamil Nadu in 2013 case. And the article surrounds freebies by the political parties and section 123 of Representation of People's Act 1951. In the context of the current debate surrounding freebies by the political parties, the term freebies means the free gifts provided by the political parties to the people, and it was discussed earlier in 2013 in the case Subramanian Balaji versus State of Tamil Nadu. And in the judgment of this case, the court held that promises by a political party cannot amount to a corrupt practice, and it is misleading to say that all promises made by the political parties in the election manifesto would amount to a corrupt practice. The court also said the manifesto of a political party is just a statement of its policy, and only when this political party forms a government, the question arises as to its implementation. The so-called corrupt practice said by the court is clearly explained in section 123 of the Representation of People's Act 1950. And here is a small description of corrupt practices under the Act. All government or non-government officials are included within the scope of corrupt practices. It includes bribery, that is any gift or promise made to a person as a reward. Then undue influence, that is any direct or indirect interference or interfere on the part of the candidate with the free exercise of any electoral right. Then the publication by a candidate any statement which is false in relation to the personal character or conduct of any candidate. Then the hiring or procuring of any vehicle by a candidate of any elector to or from any polling station.